Thanks so much to those of you in person here at the firm and to those of you online via the webinar and the magic of technology. Thanks for coming down and participating with us this morning in our webinar. My name is Jesse Berg, and I am in the healthcare group here at Gray Plant Moody, and with me is Julia Ryland, also in the healthcare group. And this morning we're going to talk for an hour or so about some of the key enforcement trends in healthcare that are happening in 2018. And before I get going and turn it over to Julia, just a few little housekeeping reminders. For those of you in person, okay, thanks. For those of you in person, please remember to get your parking validated when you leave. If you parked in the IDS, they raised the rates for the Super Bowl, and I don't know if they ever brought them down. So check with Paulette on your way out. She's upstairs, and she will validate your parking. For those of you on the webinar, there should be a chat tool where you can submit questions anytime, and feel free to do that, and either Julia or myself will read those off and respond to your questions. I also want to remind folks that we're going to be doing our annual healthcare seminar in July of this year. It's July 19th at the Minneapolis Marriott, and we'll be sending out a save the date card for that event in the next couple of weeks or so. We've got a really great program lined up, and we're very excited about that, so please join us if you can. With respect to the materials that we have today, if anyone online does not have these materials, I think you're going to be getting them in the next day or so. If there are any problems with that, feel free to send Julia or me an email, and we will email you a copy of the materials. So with that, we'll get going a little bit. And this is kind of an agenda of what we're going to talk about this morning. We thought we would do this event today because so much of 2017 was really consumed by the debate at the congressional level on the Affordable Care Act. Should we repeal it? Should we replace it? Should we just leave it as it is? There's some things happening outside of Congress still with respect to the Affordable Care Act that are going on, but on the congressional level, at least, things have slowed down a little bit. So we thought it might be a good time to talk about some of the enforcement trends that we're seeing for various kinds of providers around the country. So we're going to start out by Julia is going to go through and give a little bit of context in terms of what's happening statistically in enforcement, and then the two of us are going to kind of go back and forth on some of these topics for the next hour or so. If you have questions, feel free to ask us. Feel free to interrupt us as we go, or if you'd prefer, you can wait till we're done, and we'll field the questions then. So with that, I will turn it over to Julia.
Great. So as Jesse mentioned, we're just going to spend just a really short amount of time kind of laying the groundwork for where we are today, because of course to know where we're going, we should know where we've been. So we're going to step back and talk about some of the big players in enforcement, some of the agencies that we're thinking about, and talk about where things left off in 2017. So as all of you know, there's a lot of big players. We're going to talk in detail about what some of these agencies will be doing in 2018, but just so that we're all on the same level here, we of course have the OIG is one of the really big ones in enforcement that we need to be thinking about. The OIG is tasked with enforcing fraud, waste, and abuse when it comes to Medicare and Medicaid fraud. And so it's really active. There's a lot of different enforcement tools that are used by the OIG when it comes in this area. We're going to talk a lot about what they're doing and what they're thinking. The DOJ is the other really big one. They're tasked with enforcing federal law and has identified healthcare fraud in particular as one of its top priorities. So there's a lot of big things coming from the DOJ, and that's going to continue in 2018. Another thing on the radar, which I'm sure you're all thinking about, is qui tam relators. So these are private citizens, also called whistleblowers, who bring private claims based on the False Claims Act on behalf of the government. And generally how this works is the private citizen will, make a claim, the government will then review it, decide whether or not they're going to intervene, which essentially means join the case and bring it on behalf of the government and this private citizen. It's become a really, really big issue for healthcare providers because qui tam relators are increasing all over the place. And as we talk about later on today, the penalties that are increasing, it's going to continue to be a trend that we're seeing because, of course, key time relators get a portion of whatever the government recoups. So there's a financial incentive for these individuals to bring these cases, and there's going to continue to be a push for these individuals to bring things forward.
Can you just say that word again? I'm not.
Key tam?
Yeah.
Sure. So it's QUI space TAM. And it's just a fancy way of saying that you're bringing something on behalf of the government, even though you're just a private citizen. Think of it just as like as a whistleblower. Generally, they tend to be employees or other big enforcers when it comes to healthcare enforcement are state attorney generals. So they bring claims on behalf of the state. And then the other big player to think about are state Medicaid fraud units. So those are going to be the players that are enforcing Medicaid fraud. So as we're thinking about 2017, we're fortunate because just in April, an annual report was released for the Healthcare Fraud and Abuse and Control Program. And this report lays out in really nice detail what some of these enforcement statistics are. So it goes through talking about these different agencies, it talks about different providers, some of the cases that were brought, and it lays out what these general enforcement actions have been. So we're just going to spend a little bit of time to lay some context here. In 2017, the Department of Justice opened 967 new criminal cases. Of these, it filed criminal charges in 439 of them against 720 defendants and ultimately ended up convicting 639 defendants. On the civil side of DOJ, they opened 948 new civil healthcare fraud investigations. And at the end of the year, when you think about how many they opened and how many were already pending, there were over 1,000 pending at the end of 2017. On the OIG side of things, we have 788 criminal actions in 2017 related to Medicare and Medicaid, and then 818 civil actions. So these are some pretty significant numbers when you're thinking about how many new cases were brought just in this last year. The other thing we're going to be talking about a little bit more in detail is exclusion when it comes to OIG. So the OIG excluded over 3,000 individuals and entities in 2017, and we'll talk a little bit more about what that means and how that's going to be an impact in 2018. So the monetary recoveries out of this in 2017 were enormous. The federal government won $2.4 billion in healthcare judgments and settlements this last year. What's really startling about this number is it does not include judgments that were won for Medicaid. So when you're thinking about judgments that were awarded from the Medicaid fraud units, the statistic does not include those, even if there was a global settlement between the federal and state. So this number is actually lower than what the collective government actually recovered. And overall, as a result of actions that were started in 2016 and continued on, there was over $2.6 billion that was actually physically recouped in 2017. On the Medicaid side of things, we have those, the Medicaid fraud control units that we talked about briefly. This is just some statistics on how much they recovered and what their enforcement actions were in 2017. We have over 1,000 convictions that happened, 961 civil judgments, and over 1,000 individuals and entities were excluded on the Medicaid side. When you're thinking about how much money was recouped, we have $1.8 billion on the Medicaid fraud control unit side, and this boils down to they do this nice statistic where they compare how much, for every dollar they spend on healthcare enforcement, how much they're actually recouping. It was, for every dollar, it was over 6 that they were actually recouping. So it's really in the government's interest to pursue these cases. It's a really good way from that perspective for them to recoup money that they think was improperly awarded, and they're really successful at it. So before I turn it over to Jesse, we're going to talk about our trends and some things to look at this conversation might be a little disheartening, a little downer, so we thought we'd talk about some positive things to look forward to in 2018 before we dig into some of the negatives. So in case you didn't know, we have the X-Files. New season has been released in January, so if you're a big fan of that, you can tune in. I think there's 10 episodes or so. I think they're all out there now. Harry Potter's coming to Broadway. So if you're interested in that, it's been in London. It's been very successful, but that's in New York now this year, so you can take a little weekend trip if you're interested. For those 23 million Americans that are obsessed with the royal wedding, we have the next one coming up. I think it's in May, so you can tune in for that. And my favorite of all time, according to Emojipedia, which is apparently a real thing, phone users are going to finally be able to give their emojis red hair. So if you've been looking for that, if you've been waiting, this is your year. Now is the time you can seize the day. And with that, we'll start talking about some of the real 2018 trends. I'll turn it to Jesse.
And this one's a little darker, I'm afraid. The first one we're going to talk about is what's happening at the federal level in terms of enforcement and the opioid epidemic that the country is suffering. We're basically seeing kind of a two-pronged approach here from CMS and some other agencies. Prong one has to do with the creation of tools, data, and other sources of information that providers can use to try and address this issue. And then the second prong has to do with enforcement actions, and we've seen a number of very robust enforcement actions in this area, and that's clearly something that's going to continue. This first slide comes from CMS and is based on data in the Medicare Part D program, which of course is the prescription drug benefit under the Medicare program. Basically what this map is showing, and this is simply a screenshot, is the rate of opioid prescriptions from across the country. Now, if you go to this website at the link that you see there, you can get much more detailed information. You can sort down and look at state levels, county levels, zip code levels to try and see the rate of opioid prescriptions among providers who write prescriptions paid for by Medicare Part D. So the measure that they're talking about here is the percentage of a prescriber's total Part D claims that reflect prescriptions for opioids. Minnesota is below the national rate. The national rate's about 5.5%, so 5.5% of prescriptions reflect prescriptions for these drugs. We're at about 5.11, so we're a little bit below the national average. The highest state in the country is Nevada, which is closer to about 9% of the prescriptions written. So the policymakers on a federal level are focused on this program for a couple of reasons. Primarily, last year we saw over 42,000 people die from opioid-related overdoses. That amounts to 115 people per day dying from these drugs. The Council of Economic Affairs has come out and said that in 2015, the opioid epidemic cost the country over $504 billion, so that's almost 3% of GDP has been consumed as a result of this huge problem. So this data here comes from Medicare Part D. We've got 44 million Medicare Part D beneficiaries in the program, and according to CMS, 1 out of every 3 of those beneficiaries receives one form of opioid or another. The CMS data that they've been pushing out is really intended to give examples of some of the problems, and as we'll talk about, is pushing hospitals and physicians towards better prescribing and pain management practices with respect to these drugs. CMS gives the example in New York, for instance, of one beneficiary under Part D who had 62 prescriptions written for oxycodone in the course of 1 year. That's more than 35 times what the Centers for Disease Control says is the recommended avoidance level. So that's 35 times what they recommend avoiding. CMS is also putting out a toolkit that providers are going to be encouraged, in quotes, encouraged to use. The idea with this is to try to identify patients at risk of opioid misuse. The expectation is that providers will be using that toolkit or something equivalent to try and track patients who have issues in this area. On the enforcement side of things, we're seeing a lot happen here. Probably the biggest thing that occurred was a big enforcement action from July of last year called the National Healthcare Fraud Takedown, which is described on this slide here. Basically, this is kind of a joint effort among DOJ, FBI, the Drug Enforcement Agency, the OIG at the Health and Human Services Department, going after more than 400 defendants in 41 districts across the country, charging them with a variety of schemes for basically submitting fraudulent claims to the government. Over $1.3 billion in claims were at issue. 120 defendants were charged as part of this program. That includes 27 physicians. Another about 300 individual providers received notice of being excluded from Medicare and Medicaid as a result of this initiative. Nurses reflect the highest number of folks who were excluded out of this. There were 162 of the 295 individuals were nurses. OIG also put out a new data brief as a result of this initiative that's intended to try and identify individual prescribers who OIG believes have questionable opioid prescribing patterns and beneficiaries at high risk. So we've got about 400 individual prescribers who are identified by OIG who have been targeted for further scrutiny. A few other things on this topic. This is kind of a timeline of events that we've been seeing so far in 2017 and 2018. I won't talk about all of these, but just a few of them. Back in October of 2017, the President came out and declared this as a, quote, public health emergency, and that had some practical effects in the sense that one of the things that can happen is an expanded ability to treat opioid dependence via telemedicine that was triggered as a result of that public health emergency designation. But unfortunately, there was no additional federal funding that went towards fighting this program as a result of what the President had to say. And this kind of budget neutral approach to tackling the problem is something that we're seeing on a variety of levels. CMS sent letters to all the state Medicaid directors back in November 2017, basically asking the state Medicaid programs for input on demonstration programs to help tackle the opioid problem. And essentially what CMS said is, look, we want you to design and come up with creative tools and tactics to try to treat patients who are suffering from opioid dependence, but that has to be budget neutral too. There isn't going to be any additional federal money under the state Medicaid program for tackling the problem, so that makes it a little bit more challenging. A very concrete step from just February of this year is the creation of a new task force at the Department of Justice called the PIL task force. That means prescription interdiction and litigation. And basically the idea with this task force is to try to bring federal resources to bear on opioid producers who've acted negligently or criminally in terms of getting these drugs out on the market. The focus of the PIL task force really is on big pharma and some of the distribution by smaller pharmacies and pill mill types of entities that we've heard about. So DOJ is really going to be cracking down on those types of organizations. And we've also seen the Department of Justice take steps to participate in the large multi-district litigation against Purdue Pharma that was filed by state attorneys general. Essentially, that case involved over 200 individual cases that were consolidated in federal court in Ohio. The idea or the theory behind the case is that Purdue Pharma basically misled healthcare professionals and the public by marketing these drugs as essentially being rarely addictive and also qualifying as a safe substitute for non-addictive treatment. So 200 cases were brought. They were all consolidated. Department of Justice has stepped in and filed a motion to participate in the settlement negotiations because DOJ believes that over $4 billion has been paid out by Medicare for improper opioid prescriptions. So that is ongoing currently. A few other things that are happening at the micro level, the Joint Commission came out, the Joint Commission for Accreditation of Healthcare Organizations, which is what a lot of hospitals and other entities have to deal with in terms of accreditation. They came out with new pain assessment reimbursement and pain management standards that went into effect in January of this year. And basically the idea here with the Joint Commission standards is for hospitals to use what are called safe opioid prescribing practices and make that a hospital priority. Hospitals are encouraged to collect data, to involve the medical staff in making in efforts to try and reduce overprescribing, and also develop ways at the hospital to manage pain without opioid dependence. And CMS has taken a similar step. Those hospitals or folks listening who work at hospitals that participate in the hospital value-based purchasing program will be familiar with the Hospital Consumer Assessment of Healthcare Providers and Systems Survey. It's one of the reporting things that hospitals have to do to receive reimbursement under the Medicare program. And basically, CMS has determined that one of the questions they had under that survey could have been read in a way that would encourage prescribing of opioids, because it was all about pain management at the hospital, and CMS doesn't want to be, putting out survey questions that encourage that. So basically what they're trying to do is rewrite that part of the survey so that pain management isn't going to be as clearly linked to opioid dependence. So we're seeing a variety of different steps at both the micro and macro level on opioids.
Great. The next trend that we're thinking about for 2018 is this continued and enhanced focus on excluded parties. So I mentioned that the OIG uses exclusion as a tool when it comes to healthcare enforcement. There's generally, when you're thinking about enforcement in this space, there's two types of exclusion that you should be aware of. The OIG has what's called mandatory exclusions, which an example of that may be if somebody's convicted of healthcare fraud based on Medicare or Medicaid, the OIG is going to be required to exclude that individual from participating in federal healthcare programs. The other method is permissive. This essentially means that the OIG has discretion to exclude if they decide to do so. An example of a permissive exclusion situation would be a misdemeanor charge or conviction for something other than a Medicare or Medicaid. So there's these two kinds of routes that can happen that you can become an excluded individual. The takeaway or the effect of that means that no federal health care program payment can be made for services or items that are furnished by an excluded party. So when you're thinking about this, it has really broad implications, because the OIG has taken the position that it of course includes, the things that you would think of as furnishing items or services, providers, nurses, billing staff, things that are directly tied to these claims that are reimbursed by the government. But it can also include services that are provided by individuals that you would never think of as having a role in these healthcare claims. So an example may be somebody who's in housekeeping or on the cafeteria staff. You wouldn't necessarily think that these individuals are in some way being reimbursed for their services by federal healthcare program dollars, but the OIG has taken the position that they may be. So this is something that has really broad implications for providers and their organizations. In 2017, as I mentioned, there were over 3,000 new parties, individuals, and entities that were excluded. You can see that 1,000 of these or so were based on criminal convictions for Medicare and Medicaid. Over 300 were based on convictions for other health care programs. So it's going to continue to be something that's going to be used and have implications. But what's really interesting is we've seen some developments in this already this year. So just in February, the OIG published an advisory opinion, 1801, that talked about the gray lines between employing excluded individuals. So essentially what happened in this advisory opinion is there was an individual that had been convicted of Medicaid or Medicare fraud, and as part of that conviction and as part of the settlement that was reached under the False Claims Act case, this individual agreed to be permanently excluded from participating in federal health care programs. So it was acknowledged that this individual was entirely excluded, but they received an employment offer from a company that basically provided this company would go out and negotiate discounted rates from retail pharmacies, and then would contract with long-term care pharmacies for these discounted rates. So they were in the healthcare space, but they weren't themselves, directly providing services. And this individual was offered an employment opportunity where they would be involved in going out and marketing on behalf of this company. They would go out, talk to long-term care pharmacies, try to get them to contract with the company, and then, get these access to these discounted rates. So the issue was, does this marketing efforts, is that something that's reimbursable by federal health care program money? Because if it is, this individual is prohibited from engaging in that employment relationship. The OIG ultimately concluded that employment of this individual posed minimal risk, and it did so for a couple different reasons. The biggest one was that this organization, this company, did not directly bill the federal government. So they weren't submitting claims, they weren't receiving federal dollars directly. What's interesting is the OIG, though, did acknowledge that there was the possibility of an indirect arrangement here, because the long-term care pharmacy was actually billing the government, and if that reimbursement that they were receiving covered the acquisition costs for them getting these drugs, how much, whatever it took for them to get this discounted rate, you could go down the path and say that it started with these marketing services that were provided by this employee. So it tells you how broad the OIG looks at some of these employment arrangements. But ultimately, it concluded that the employment arrangement was very narrow. This individual would only be providing marketing services. The services were in no way tied to what drugs were being purchased. That was up to entirely the pharmacy and the patients. The contracts played no role in what was actually ultimately purchased or reimbursed by the federal government, and so the OIG concluded that the risk was minimal. What's interesting is, of course, these are very limited opinions, so you can't rely on them. They're specific to the facts. So it's not as if to say that the OIG has now blessed in any way these types of arrangements. You really need to be careful and think about what the facts of the particular employment are. And our recommendation here would be, of course, to continue to screen employees and contractors against the OIG's list of excluded individuals and entities and the system for award management. Those two databases should be screened. And then if you think you have questions about whether you're in that gray area, it's something that you should definitely look at further, because the penalties can be significant there.
Question?
Yeah.
So if you're a healthcare provider, do everyone you contract with, are you required to do background checks on contract Google, and our Google now has to validate that number? How does that, where is the
Good. So the question was, where's the line when you're thinking about vendors and contractors about how far you have to go with requiring your contractors to screen their employees or entities? And it really, when you're thinking about it from an organizational perspective, you really need to think about your own employees and your own contractors. Typically what we do is we do put provisions of subcontractor arrangements that require the subcontractors to screen their own employees that are involved in the services that are potentially reimbursable. So it really does tie back to what services are being provided and whether they're reimbursable by the federal government. Google or somebody like that, probably not so much, but if you're involved with vendors that do play a role in that, it should be something that they're required to do, because it could, down the line come back to you.
The next one we're going to talk about is something that's really challenging for providers, because the government has really been kind of all over the place on this, and this has to do with value-based programs, reimbursement programs, and fraud and abuse compliance. One of the big parts of the Affordable Care Act was this initiative to say, okay, let's stop paying for volume, let's start paying for value, let's reward positive results and good outcomes and reduce costs. And we saw literally dozens of programs rolled out under the Affordable Care Act under this broad kind of concept of value-based purchasing. And that just means purchasing. The idea is that Medicare is the purchaser, so they only want to buy services that have certain value associated with them. CMS was very aggressive with this. They basically said we're going to have 90% of Medicare payments tied in one form or another to value-based reimbursement by 2018, and they wanted more than 50% of Medicare reimbursement to flow through what are called advanced payment models. So those are things like accountable care organizations, these bundled programs for care improvement, and a variety of other types of arrangements. We're also seeing this at the state level. More than 40 states have initiated their own independent programs to move towards value-based purchasing in one form or another. Half of those programs involve multi-payer arrangements, so it's not just Medicaid, it's commercial payer-based arrangements as well. We have 17 states that have their own accountable care organization type programs that they're rolling out. And in the entire country, there are only 7 states that really haven't done anything on this value-based initiative. So it seems like it's a trend that's here to stay. What's been challenging, though, is at a federal level, we've really seen a shift. Under the Obama administration, a lot of these programs were basically mandatory programs, and now with the new administration, we're starting to see much more of an emphasis on making them voluntary programs. At the same time as all of that is happening, we're starting to see studies come out from some of the clinical and financial associations that evaluate these programs that basically are saying, you know what, we don't know if these things really are working as well as everyone thought. End of 2017, we saw 2 important studies. The Annals of Internal Medicine came out with a study that indicated that the value-based physician modifier really wasn't associated with better quality or lower spending in physician practices. And Health Affairs, which is a trade journal, put out a study that year as well that basically found that the hospital value-based purchasing program, that rewards hospitals for low costs, but it doesn't really do anything if those hospitals also have low quality. So the programs, according to Health Affairs, weren't really driving quality. In terms of the specific programs that are out there, we've really seen a roller coaster of programs, and I've listed a few of them on this slide here. One of the biggest for physicians came in the form of 2015's MACRA law, that stands for Medicare Access and CHIP Reauthorization Act. And the big thing about MACRA was it's what did away with the old sustainable growth rate formula under Part B of the Medicare program, which was something a lot of providers objected to because the sustainable growth rate was going to result in lower Medicare reimbursement each year. So Congress repealed that. They replaced it with this MACRA program, which broadly speaking is intended to incentivize physicians for quality in the care that they deliver. The MedPAC, which stands for Medicare Payment Advisory Commission, however, recently voted 14-2 to recommend to Congress to repeal MACRA altogether, to do away with the merit-based incentive payment system for physicians. So that leads to some uncertainty for doctors. A number of the programs that were considered mandatory have really been scaled back. In 2016, CMS rolled out 2 programs, 2 bundled payment programs. One was called the Episode Payment Model. Another one was called the Cardiac Rehabilitation Program. Those were all set to start in 2017. The Trump administration delayed them in August of 2017 and then finally canceled them altogether in November of 2017. And the administration also scaled back another mandatory bundling program, which was the Comprehensive Joint Replacement Program, which was intended to be one big rate for hospitals and physicians who work on these expensive joint replacement procedures. Those have now been made mandatory in less than half of the jurisdictions that were as compared to where they were supposed to be used, and they're voluntary everywhere else in the country. A big objection to these programs that providers have is, you know, how do we comply with the Stark Law in terms of these programs, and that's something that CMS has really struggled with. The theory there is that the laws on physician referrals, with their financial relationships between the doctor and the organization where the doctor refers, they're really written for fee-for-service-based medicine. So these programs that are intended to incentivize collaboration among hospitals and physicians and other providers who aren't integrated necessarily, those laws get in the way of that kind of collaboration, and that's been a big problem for organizations as they've struggled to try to figure out how to participate with these value-based programs. There is right now an interagency work group among DOJ, HHS, and OIG, basically looking at whether they need to amend the Stark Law or what kinds of things they can do to make the Stark Law a little bit more user-friendly for these programs. There was legislation that was passed out of the House Ways and Means Committee. It's called the Stark Administrative Simplification Act. And the idea with that is to try to limit penalties for technical violations and also create a new reporting mechanism for technical violations that's intended to help providers with some of these programs. On the voluntary front, we've seen a brand new program called the Voluntary Bundled Payments for Care Improvement Program that was just rolled out in 2018. This is similar to some of the other programs. The idea with this is that hospitals and physicians can earn extra money for their Medicare Part A and B services related to specific types of care. So things like joint replacements, kidney failure, spinal fusions, treating people who have strokes. The idea is if the participating providers are able to deliver care for these care episodes below targeted cost levels while still hitting certain quality targets, the hospitals and physicians will receive a bonus under this voluntary bundled payments program. The challenge with programs like this, though, is that there are no fraud and abuse waivers that are specific to this program. So basically what we've seen with any of these programs is that providers are forced to go either try and fit their arrangement into existing Stark Law and exceptions in anti-kickback statute safe harbors, which can be challenging, or spend time sorting through the fraud and abuse waivers that are on this slide here. And if you've not looked at these before, it's interesting to spend time with it because they're extremely complex. If you think the Stark Law exceptions themselves are complex, these really are at a whole other level. They typically will involve dozens of elements, very technical requirements. The waivers generally are temporary. They only apply to the participants working in the specific program at issue, and all of those participants will have to have signed an agreement with CMS related to their participation in these programs. Unlike the waivers that we see in some other areas, these don't apply to commercial payer arrangements, so this will only be specific to the Medicare value-based programs at issue. So they're challenging. They'll be 13, 14, 15 pages long in terms of explanations and elements that need to be met, and it's challenging for providers to have to use those programs. So as a result of that, we're seeing providers still need to rely on advisory opinions to try to address these arrangements. We recently saw an advisory opinion from 2017, which is the first opinion that blessed paying for costs of lodging and meals and transportation under a new exception to the beneficiary inducement law. That's the law that basically says providers can't give things for free to patients to try to induce them to come back for medically necessary services. The Affordable Care Act created a new exception to this beneficiary inducement prohibition, and OIG rolled out an advisory opinion in 2017 outlining how these kinds of arrangements can work. On the aspect of providers sharing financial benefits through some of these joint replacement programs and other value-based purchasing programs. If you're not in the world where you can rely on the waivers that CMS has rolled out specific to these programs, and you don't think that existing Stark Law exceptions can be, sort of used to try and protect your arrangement, then again, you're back looking at advisory opinions for guidance on these kinds of things. OIG rolled one out towards the end of 2017 having to do with gain-sharing distributions. Basically, this involved a program where participants received the physicians receive per capita distributions based on hitting quality targets and cost-saving reductions in the context of a gain-sharing arrangement. And OIG said it was fine under the anti-kickback statute. That, of course, only applies to anti-kickback. OIG doesn't opine on the Stark Law. And there are very few Stark Law advisory opinions that are out there, so it's not really a place folks can go to try to get guidance on figuring out how to sort of navigate arrangements that don't fit well well within an exception. But one of the good takeaways from this kind of advisory opinion is OIG will, generally consult with other agencies about their concerns with these types of arrangements. It seems pretty unlikely that OIG would have blessed this under the anti-kickback statute if CMS would have thought that the per capita distributions among the physicians for hitting these cost-saving targets under the gain-sharing program would have been problematic under the Stark law. So, advisory opinions are a place to go for folks. There are a number of potential fixes being debated in terms of the Stark law. Folks have been talking about, can we repeal it altogether? That seems doubtful, of course, because there is a vested interest in keeping that law around. Another slightly more interesting idea is potentially changing the Stark law to make it only about ownership arrangements and not really about compensation arrangements. As initially envisioned, the Stark law was kind of driven by concerns about ownership doctors have in practices where they refer ancillary services. So that might be something that happens. Of course, that would take a congressional act, which is very challenging. Other ideas, new exceptions or potentially scaling back some of the penalties that are out there for these technical violations or other things that are being debated in terms of fixing the Stark law. But unfortunately, this is an area where if you're trying to participate in these programs, it's challenging because you don't have clear direction from the federal government in terms of the future of these programs, and you really don't have clear direction in terms of the Stark law and kickback safe harbors and exceptions.
Great. So another thing to keep on your radar is just the simple fact that penalties are continuing to increase for fraud, waste, and abuse. We've seen this as a trend going, back until, well, we've seen it as a trend for a while, but specifically in 2015, there was the False Claims Act requirement that it needed to be adjusted, penalties needed to be adjusted based on the Consumer Price Index. So this has been happening, annually for that reason. Back in 2015, penalties increased kind of for a catch-up period from 5,000 to 11,000, went up to 10 to 21. And 2017 now, this range again went up from 11,000 to 22,000 approximately. So we're seeing penalty figures continue to go up. The biggest development, though, is there were some significant increases in 2018 from the Bipartisan Budget Act. So we've seen penalties under the civil monetary penalty law, specifically those for improperly filed claims, were doubled. So that's significant. They went up from, $10,000 turned into $20,000, 15 turned into 30, 50 turned into $100,000. So those fines have all been doubled. When it comes to civil monetary penalty law, penalties for inducing or limiting services, those increased, and so we've seen that happen. Perhaps the most troubling is under the anti-kickback statute. Those were significantly increased. So penalties under that law went up from $25,000 to $100,000. So these are some very significant changes and increases to the penalties that are going to be imposed for violations of these laws. It has a significant impact on providers. You can see that this is just a chart that shows the amount that's been recovered based on the False Claims Act, and you can see the trend is it's moving on up, and that's only going to continue. And the risk that it poses, of course, is that the financial risk when it comes to certain arrangements is only going to increase. This means that when there are, potentially even just technical violations, your risk has gone up significantly based on these penalty changes. It also has the potential to spark additional key TAM stuff, cases being brought by whistleblowers. As we mentioned, they stand to recoup a portion of what the government recovers. So when you're thinking about penalties for the False Claims Act going up, there's an even higher incentive for these individuals to bring these cases. So we could see cases under that law continue to increase as well.
Yeah, and another one has to do with space sharing. This is interesting because when folks used to think about space sharing, so that basically means, you know, can a hospital and a physician or any other type of provider, lab, surgery center, imaging center, durable medical equipment center, what can they do to share space? Can they all kind of co-locate within the same space, or is that going to be an issue for them? And when folks used to think about those arrangements, it typically was, well, is it a Stark Law violation? Is it an anti-kickback statute violation? Or is the lease set up to comply with Stark Law and anti-kickback? And if that's okay, then, you know, then maybe we're going to be fine. But we've really seen a change in emphasis from CMS over the past few years on this, and it isn't really driven by changes in statute or changes in regulation. Statute and regulation are basically the same as they've been on these topics for a very long time. But what we're starting to see now is more sub-regulatory guidance. So that's changes to the various manuals that govern the operation of the Medicare program, where CMS is really cracking down on these arrangements. And last year we saw new changes in terms of the definition of a hospital. What does it mean to actually be a hospital, which probably folks thought, you know, that wasn't all that controversial. But what happened was there was enforcement action against a hospital in Missouri in 2017 where CMS came into a rural hospital and they basically said, you know what, you're not functioning as a hospital because you don't have patients here on the level we expect for an inpatient hospital to operate and be paid as such under the Medicare program. So CMS went so far as to terminate that hospital's provider agreement. That got the senator from Missouri, Claire McCaskill, very interested in trying to get clarification on what does it mean to be a hospital, and the upshot of all of that was changes to the state operations manual and additional guidance to state surveyors that they're supposed to use when they go out to look at hospitals and decide whether they're really meeting the definition of a hospital. So basically what happens is surveyors need to find out whether there's an average daily census of at least 2 inpatients who have a length of stay of at least 2 days. They're supposed to look at things like whether the hospital has nurses, pharmacists, physicians available on a 24/7 basis to try to render services to these inpatients. And what the government's really concerned about here are organizations that are kind of holding themselves out as hospitals but aren't doing everything that they need to be doing under the Medicare conditions of participation to qualify. They're focused on that. They're also focused on hospital outpatient departments under the provider-based rules. And the issue here is there's actually a couple things. The first thing is, you know, is it right, is it fair that there are reimbursement differentials for the same services between when they're rendered in physician freestanding locations versus hospital outpatient locations? That's been a debate that's been going on for many, many years. Starting in 2015 and continuing through 2017, we saw crackdowns on the ability of hospitals to enroll what are called new off-campus provider-based departments. There is a grandfathering exception to that rule that basically says if you were in place prior to the passage of the law, you can continue as such, but you can't add new off-campus provider-based departments. And what CMS is worried about is too much money being paid for these hospital outpatient services. So they scaled back the ability to providers to enroll new provider-based locations. They also cut down the reimbursement generally for provider-based services starting in 2018. It's now being paid at 40% of what it used to be paid under the outpatient prospective payment system. And the 2019 budget that was proposed by the administration would actually eliminate this grandfather exception altogether to this moratorium on new provider-based facilities. So there's this focus on the reimbursement side of things, and then there's also a focus on patient confusion. CMS for a long time has been worried about patients showing up at hospital departments and not really realizing that they're in a hospital department. And the reason that that matters is because under the old rules, the individual would basically be billed more personally for services rendered in the hospital outpatient department than they would in the freestanding physician clinic setting. So CMS has been doing things to try to crack down on the ability of hospitals and usually physician groups to share or co-locate these provider-based arrangements. So we've seen a couple of things there. Starting at the end of 2017, CMS rolled out a new provider-based checklist that it wants all of its Medicare administrative contractors to use when they go out and they survey these organizations that are saying that they're hospital departments. CMS was concerned that there's an inconsistency among the surveyors in terms of deciding whether organizations are meeting the various requirements to be a provider-based facility. And we're also seeing and hearing from CMS that they're going to be rolling out new, what they call sub-regulatory guidance on these definitions and these terms. So again, that would be commentary in the various Medicare manuals on how far a hospital and how far a physician group can go in terms of sharing things like waiting rooms, hallways, bathroom facilities, registration areas, treatment areas. All of these things, all of these rules have basically been the same since 2003, but beginning in about 2011, when the CMS regional office in Chicago issued a letter to a hospital and a radiology department in Indiana, where it went through in great detail and explained why CMS didn't think that the radiology department was sufficiently integrated with the hospital to be provider-based. We've heard this kind of drip, drip, drip of guidance, usually in an informal setting from CMS on these issues. So it's things like comments and public speeches by various CMS officials, PowerPoints put out by various surveyors who work on these hospital issues, and they've been promising and promising and promising for a while that they're going to issue clear guidance on how far a hospital and how far a physician group can go in co-locating. The reason it matters is because we have seen enforcement actions against these arrangements, particularly in rural areas where historically it's been the practice for physician groups to send a doctor or two up to a hospital maybe once or twice a month, lease some space and use that space to try to operate a physician clinic to see the doctor's patients who reside in that community. There have been some enforcement actions based on that type of arrangement as violating the provider-based rule, and it's a big deal financially because if you get it wrong, the hospital is at risk for having to refund the difference to CMS for the higher reimbursement under the outpatient payment rule.
All right, we're also going to see just an overall kind of broad continued focus on prosecuting fraud, waste, and abuse cases. So we talked about some of these figures before. The enforcements and the recruitments have been significant over the last year. There's this additional focus that there seems to be on targeting patient and beneficiary fraud abuse. So that tends to be things like if a beneficiary misrepresents their circumstances so that they can obtain coverage for a service to which they weren't entitled, if there's, this concept of card sharing where they're sharing insurance cards and they're using services, doctor shopping where they're going and getting prescriptions from multiple physicians for the same thing. So there's all these different ways that beneficiaries can be involved in fraud just like providers can, and there seems to be this new focus, enhanced focus on targeting some of that. What's really interesting is that there is a push to get providers involved in some of this. So there's a push to have providers ask for additional identification to make sure that card sharing isn't happening, and a push to check databases to make sure that drugs aren't being purchased by multiple providers down the road. So although the target seems to be on these beneficiaries, there's an additional push to hold providers kind of accountable for playing a role in protecting some of this fraud. What's also really interesting is when you think about from an agency perspective, how much they are focused on fraud and abuse cases. So as I mentioned, the OIG is involved in some of this, and they play a particular role when it comes to overseeing the Medicaid fraud control units. And they're involved in trying to figure out ways to enhance enforcement on behalf of those agencies. And one of the things that they're doing is putting out these numbers for indictment versus conviction rates. So they put out these goals on how much they actually hope that these Medicaid fraud control units indict versus convict. And you can see that the targets for 2019 are pretty stark. The conviction rate that they're hoping for is 91%. So they're using data, they're going back, they're looking at what their success has been, what some of their issues have been, and they're crunching numbers to figure out how they can be more successful in the future to make sure that their success when it comes to enforcement continues to increase. On the bright side, if there is one, we do have this kind of, initiative by CMS to simplify some of the documentation requirements. So, the quote from CMS is that it will allow you to focus more on your patients and less on confusing and time-consuming claims documentation. So, at least they're acknowledging that there seems to be a lot of confusion when it comes to some of those claims things. So, you can look up some of these on the CMS website. Some examples of things that they're doing are before they would deny a claim if a nurse initialed based on the medication log. Now CMS is saying, if the provider that's responsible for care has signed the medical record appropriately, we're not going to deny claims if the support staff or other personnel are initialing certain things. So they're trying to reduce some of those really technical things that would bounce claims back, and you can look up more. So that's, potentially a happy one.
That's good news because people still are having trouble with figuring out the claim forms and having to do things like self-disclose problems to various agencies. This slide here just is some statistics about the Stark Law Self-Referral Disclosure Protocol going back to its beginning in 2011. And you can see here the number of claims self-disclosed and the amount settled with CMS when making these disclosures. The detail, CMS is a little bit cagey in terms of sharing a lot of detail about these kinds of arrangements. The most common violations tend to involve things like violating personal services arrangements exception and the non-monetary compensation exception, but you can see the statistics here. The reason this has been interesting and challenging to providers is because the Affordable Care Act, one of the things it did is it created this new requirement to report and return overpayments within 60 days of identification. And that's something that the government has been talking about for a very long time. They first proposed that in 1998 and also in 2002. They ultimately pulled their proposed rule in those years because it was too difficult to operationalize. They didn't feel that providers could do that within 60 days of identification. But it's now on the books, and we're also starting to see organizations hit with enforcement actions for failing to report and return overpayments within the identified time frame. This case here is interesting for a few reasons. It could be one of those situations that gives truth to the adage about how bad facts make bad law, because there's some challenging things going on with this dental dreams case, and I'll talk about those in just a second. A couple of interesting points, though. First of all, this only involves Medicaid dollars. There's no Medicare in dollars here. This is just Medicaid dollars. It also just involves dental services, and we don't usually think of dentistry as an area of False Claims Act and overpayment enforcement. And also it involves a claim filed by a dentist. So the relator, the key TAM relator in this case, was a dentist who was upset with what was happening at his practice. And basically what was going on here at the Dental Dreams organization is that the relator dentist worked at this practice and essentially found out that there were some bad activities going on. The practice, he felt, was basically just forging claims. They weren't upcoding, they weren't using the wrong modifier, they weren't making mistakes with very technical things like about whether the right level of supervision was present. They were just essentially lying on the claim form, according to the relator. So he went to his boss and said, I think this is happening, I think we've got a problem, I think we need to do something to fix this problem. And the boss essentially said, I understand that, I understand what you're saying, what's going on, but we basically can't afford to investigate that. It's going to cost us too much money. And so the relator complained a little bit more. He ended up being fired by this practice. There were also some other sort of pretty unfortunate things going on. Allegations of employment discrimination, sexual harassment, and disability discrimination are at issue in this claim. But the relator told his boss, I want the claims to be refunded. That second bullet point there, that actually should be reversed. The relator told the defendants that, and the defendants basically said, we can't do that. They fired the guy. He filed the key TAM case, basically alleging a theory of a reverse false claim, and the idea there is that the dental practice knew of this overpayment because the relator gave them information about the overpayment, and they refused to report and return that overpayment within the requisite period of time, and they didn't want to even investigate it. They basically just said it was going to cost too much. So this case is happening right now. There was a motion for summary judgment filed by the practice trying to dismiss the False Claims Act case. The court rejected that motion and basically was persuaded by the fact that the relator had informed the practice of the improper billing and what the practice had said about not investigating the matter. So it survived motion for summary judgment, and there's actually a trial that's scheduled to begin very soon that may have been delayed. It's a little unclear from the guidance that's out there, but this will be an interesting one to watch because it's all about the provider's ability and obligation to report and return these overpayments within the period of time at issue.
HIPAA. HIPAA is going to continue to be a really big thing in 2018. There's two main things you should know. We included kind of a lot of information on these slides, but you can feel free to look at them in more detail. We also have an alert on our website that talks about this. But the first thing that you should know is there's been some discussion about HIPAA and texting. This started back in 2017. There were reports that emerged that CMS had come out with this big, no texting ban, and the reports, the guidance from CMS actually took place via email. But of course, it spread and everybody was in an uproar because there had been before that point, no position had been stated about texting, and so it was kind of a new position to take. At the end of December, a memo was released that kind of stepped this position back a little bit, took a little bit of more nuanced position on the texting ban that had been talked about. Essentially what it says is you are not allowed to text orders from a provider to a member of the care team. That's not allowed under the Medicare conditions of participation. When it comes to other texting, it's permitted so long as there's a secure and encrypted messaging platform that's being used, and of course, as long as you tick off some of the other requirements under HIPAA, you have all the policies and procedures in place, and you do all of that. So this texting issue is one, of course, that's a hot one because it's being used all the time now, and it's kind of some of the first discussion about whether it's allowed and whether it's not. But the other big thing to know when it comes to HIPAA enforcement is OCR has been doing these audits of covered entities and business associates, and back in September of 2017, they released the preliminary results of this, and the results were pretty poor, to say the least. OCR was not happy. The audit protocol, if you look at it, the things that OCR was looking for is really intense. They go through the regulations and they basically have paragraphs about all the questions they're going to ask, all the things they're going to look at, and then they would give a score for these audits. A score of 1 to 2 means you're in full compliance, all the way down to 5 means there's no evidence of any serious attempt to comply. And what OCR found was the majority of entities that were audited failed by a long shot. This comes down to things like notice of privacy practices were inadequate, there was no proper security risk assessment, all the requirements under HIPAA. The takeaway for this is these audits have been going on for a long time. HIPAA enforcement has been a trend that we've been seeing increase. The results of these audits likely mean that OCR is going to take an even more aggressive stance because they're finding that organizations aren't up to par with what they think they should be. So now is the time to really look at your HIPAA materials, to bring them out, make sure that you could stand up against an audit, conduct one yourself if that's possible, and really make sure that you're prepared to respond to some of the questions that OCR could be asking if it comes down to it.
We're also seeing more and more creative False Claims Act theories that are going on. We still have all the classic ones, kickbacks, under cash under the table, that kind of thing. But we're really seeing more expansive and innovative interpretation of this law. And I'll just talk about a couple of these quickly. The second one here, this U.S. ex-rel Tulio versus Medicor Associates, is interesting. This is a False Claims Act settlement for about $21 million, and it was based on violations of the Stark Law. Well, what's interesting about this is that the violation of the Stark Law that was at issue in this False Claims Act case was basically just the fact that we had lapsed medical director agreements. So what had happened is that these contracts expired and they kind of continued on, and there were payments to the doctors providing medical director services, and they referred patients to the hospital. And the False Claims Act case was brought. The defendants tried to say, you know what, okay, fine. The exception for fair market value and personal services arrangements talks about having a written agreement in place, and we recognize that we may not have had a classic written agreement in place, but there's no debate about the services being provided. There really isn't any debate about fair market value and kind of the elements of that Stark Law exception, other than the fact that we didn't actually have a written agreement. And they also said that 6 of the 8 medical directors could theoretically satisfy the Stark Law exception based on this idea that you can kind of create compliance through a pile of documents theory, and that's the idea of, you know, I've got emails, I've got notes in the file, you know, communications going back and forth where we both can kind of construct the fact that we were comfortable with this arrangement. So even though maybe we didn't have this perfect, beautiful contract, we still were meeting the substantive elements of the exception. And so they tried to dismiss it on that basis, basically that it wasn't material to the False Claims Act case, that it was minor enough that it really shouldn't matter. The court rejected that theory and allowed the case to go forward, which has resulted in the settlement. The court basically said, no, the writing requirements of these exceptions are material to the arrangement, because otherwise the court can't really figure out what the arrangement was at issue and whether the parties involved were complying with the exception. So that's a bit of bad news for organizations. A couple other interesting settlements. We talked earlier about this beneficiary inducement idea, which is where you're giving things to patients to try to get them to get services from you. And the DaVita organization was involved in a large False Claims Act settlement, almost $64 million, and a big part of that had to do with what the government felt was improper beneficiary inducement activities going on there. DaVita allegedly was doing things like writing off beneficiary debt. They weren't doing that based on financial need considerations. They were giving discounts to beneficiaries based on paying for things with credit cards. They were using manufacturer co-payment cards in lieu of collecting co-payments from the beneficiaries. So those kinds of activities got the government's ire up in terms of the DaVita enforcement action. And then the last one I'll talk about is this False Claims Act against the Family Medicine Group out of South Carolina. For a couple of years now, we've been starting to see more and more Stark Law enforcement actions based on physician compensation within a group practice. For a long time, people felt like, you know, if you're complying with the definition of a group practice under the Stark Law, you've got a lot of leeway in terms of compensating your doctors. You can't do everything. There's still rules that apply, but it just hasn't been as much of a enforcement priority for the Department of Justice. 2014, we started to see cracks in that theory a little bit. There was an enforcement action that year against a group that had apparently been distributing profits from imaging services that the doctors ordered in a way that DOJ felt violated the Stark Law. And this Schaefer family medicine arrangement is kind of the same idea. Apparently the compensation plan at issue at this group involved paying doctors what was referred to as a percentage of value for lab tests and diagnostic imaging tests. And it seems like the theory that this group has is that they were trying to figure out a way to compensate doctors in a way that rewarded value under some of these value-based programs that I was talking about earlier, but they didn't really quite figure it out, at least according to DOJ, in the way they should have. So they ended up having to settle for about $2 million on that one.
All right, and the very last trend for 2018 is this increased focus on the state level for elder abuse. So back in November, the Star Tribune released a five-part series talking about the failure of protecting vulnerable adults in Minnesota, and it really goes into detail about how poor the state has done at investigating these complaints, at pursuing these claims, and digging into it. Following that, Governor Dayton formed a task force, and we had in January the task force first final report that called essentially for tougher penalties when it comes to elder abuse. Then in March, we had the Office of Legislative Auditor did a report and an evaluation of Minnesota's Office of Health Facility Complaints, and that's the office that's actually tasked with receiving these complaints of elder abuse and investigating them. And what was found was that this office did a really poor job at pursuing and investigating complaints. The report is 122 pages long. It's rather scathing. It goes into a lot of detail, talks about poor internal operations at this Office of Health Facility Complaints, and also just the complex regulatory environment that surrounds elder abuse as the two main reasons that there continues to be such a failing of this population. There are 2 bills right now, so we're hoping and likely going to see some legislative results to address these issues. They're, at the very early stages. Some of these things that are happening is it permits families to record and videotape private residences. So there's some measures that are being taken and proposed to help give families a better shot at catching these things. There's mandatory reporting requirements saying that there needs to be follow-up on these complaints, and then a number of different measures. So that's something to keep on your radar. We may see some legislative action when it comes to elder abuse.
And with that, we're sorry we went a little bit over, so we appreciate your patience. We're happy to stick around if anyone has questions or want to talk about any of this in more detail. Thank you so much for coming down today. Thank you so much for all of you listening online. Both of us are happy to try and field any questions you might have. We appreciate it.
Absolutely. Thank you.
Thank you.